Hey there, Ed McCormack here, founder of the crypto education platform Dchained. It's been almost 2 months since we last spoke about the lawsuit between the SEC and Ripple. And in that time, there is a whole new development that could ultimately not only change the verdict of this case, but also how digital assets are classified by regulatory bodies around the world. And we're going to talk about all of that right now. So to begin, let's first dive into some background on this case. And it all started in December of 2020 when the former chairman of the SEC, Jay Clayton, one day before stepping down from his position, filed a lawsuit against the current CEO and former CEO of Ripple Labs, the creator of XRP, the cryptocurrency. And this lawsuit stated that the two executives from Ripple Labs knowingly and willingly transacted on an unregistered security. Now, we'll talk more about what that means, but it's a huge indictment against two, very well-known and established executives, basically stating that they broke the two cornerstone federal laws of all securities. And what those state is, one, it broke the registration requirements set forth by the Securities Act of 1933, which ultimately stipulates that when you want to offer up a security that people could invest in, you need to provide all the relevant and pertinent information that investors need to know. It's basically a protection for investors so that you are not given faulty information or inaccurate projections. It was something that was put in place shortly after the Great Depression as a means of alleviating a lot of the not so transparent business practices that were going on when stocks were going public at that time. The other piece is how it's traded. And ultimately, the SEC says that these two executives not only didn't register a security, but still moved forward with allowing people to invest in it and ultimately allowed this new cryptocurrency, XRP, to be publicly traded. And that's ultimately breaking Securities Act of 1934, which covers how securities are bought and sold. Now, in saying that, Ripple has held no punches back. And ultimately, the motions that they've put forward and the case and defense that they have really sort of pushed the court to bring out a lot of the truth from the SEC ultimately brought out a lot of dirty laundry that the SEC probably would have wanted to keep out of the public eye. And it really started with the defense of fair notice. Now, fair notice is a basic statute in the Constitution that says that you have the right to know what is and is not legal. Ultimately, by law, you should know what is permissible and what could get punished. And in saying that, the two executives from Ripple ultimately stated that the SEC not only acted in a way that was misleading and ultimately intentionally provided some very vague guidelines for how digital assets need to be classified, but they also waited 7 years before filing this. And ultimately, the timing of it was very peculiar because the SEC is making this case that all of the transactions that have occurred in those 7 years were in effect illegal. And Ripple calls into question how much time needs to elapse before you're sort of on the hook for saying, whether that should have been or should not have been registered. So that was very interesting. The other, and this was potentially backbreaking for the SEC, was that two former commissioners, so two executives from the SEC, actually came forward as whistleblowers and corroborated with Ripple's statement that the SEC intentionally acted in a very vague manner so that they can continue to operate with oversight over digital assets, but also provided a foundation where at any point, if they wanted to file a case just like the one that's going on right now, they could ultimately do so and collect a lot of money in fines. And coming out of that, the two executives from Ripple ultimately then won a motion with the judge presiding over this case to have the SEC pretty much uncover and declassify internal communication across different executives within the SEC, where Ripple believes that these executives knowingly state that they actually group Ripple alongside Bitcoin and Ethereum, two digital assets that the SEC has come forward and stated are commodities. And if that's the case, a commodity is not a security. So by definition, that would mean that XRP is exempt from having to register as a security. And this latest development ultimately adds a whole nother layer. Not only has the SEC basically defied the court and not produced any of the documents that it was ordered to do back in early June, but Ripple has now come forward and stated that they have evidence that the SEC actually produced a policy in January 2018 that stated that its own employees were permitted to buy, sell, and hold digital assets because the SEC does not view digital assets as a security. And therefore, any buying, selling, holding of these digital assets would not be restricted by SEC regulation. And that is backbreaking because that essentially is having your hand in the cookie jar. It is stating that the SEC, in plain English, is saying our own employees could buy this because it's not a security. And we are about to see if the SEC ultimately abides with this motion that just this last week that Ripple has filed. And ultimately, we are looking at by roughly around Labor Day, SEC has to actually produce all of these documents that they have been ordered to do by the judge. And if they don't, the judge, in effect, could wind up dismissing this case if the SEC continues to not comply with court orders. Now, that being said, we are far from the end of this saga. And I think it should be called a saga rather than a lawsuit because there is so much drama and layers involved that, there's nothing more to do than just grab some popcorn and just watch this thing unfold. But nevertheless, this has a lot of massive implications because ultimately it then, if the SEC settles this case and claims that they were in the wrong and they did not specify, the proper classification for how digital assets should be, seen by the courts, that could undo a lot of cease and desist and other, legal actions being taken against exchanges, cryptocurrencies, and even, the way that, certain projects have been banned from the United States. So it'll be very interesting to see how everything unfolds. But nevertheless, continue to tune in because we love to cover this. It's something that not only can have a big impact on the crypto community, but it also is, groundbreaking in terms of introducing a whole new asset class that, that we're all going to be sort of investing into at some time or another if you're not already involved. So I hope you found this video interesting and helpful. And if you did, please subscribe to this channel, pound that like button, and of course, tell your friends and family. We are always looking to grow the Dchained community, and we love your support. So until next time, happy and safe investing. I'll speak with you soon.